And the federal government showed it isn't done with the false asset declaration case against Senate President Bukola Saraki just yet. Just yesterday, the government filed an 11-ground notice of appeal through its lawyer Rotimi Jacobs and Pius Akuta, an assistant chief state counsel, at the Court of Appeal in Abuja. The Court of Conduct Tribunal had on June the 14th cleared the Senate President of 18-count charge of false assets declaration. Let's now get more perspectives on this from a lawyer joining us in the studio, Olayinka Ola Daniels. Thank you for your time. Are you impressed, first off, about this move by the federal government? Very impressed. Was it expected? Because many thought that was going to be the normal run in the mill, that once a political bigwig is exonerated at the first level, they might not even
well, what
appeal.
is expected is another thing entirely, because until when the panel of the anti-corruption crew spoke, that is Professor Saraki, until when he spoke, nothing was done. There was no clue whatsoever. But when he spoke, everybody came back to the table and they said, this can't just go. Because if you look at the decision of the CCT, I will call it judicial rascality. Seriously, it is sad. Even the CCT is contradicting his own ruling and the judgment of the Court of Appeal. It made a ruling as of 24th of March 2016 about some of these decisions. Now, by June 14, he overturned his own ruling and overturning also the judgment of the Court of Appeal. It is sad. Here we are. One, by the virtue of I think paragraph 2, sub 2, sub 3, and sub 13 of part 1, that's the 5th schedule of the 1999 Constitution, as amended, it was clear that the honor of proof is on the public servant. So the honor of proof is on Saraki to tell us that there is no infraction whatsoever in his form.
But there's still the burden of evidence on the part of the prosecution, and of course the CCT said it was not able to prove
the only thing that is required from the prosecution has been done. That is to come to say there is infraction. Investigation has been done. In fact, the CCT also in their judgment claimed that Saraki was not invited, which was clear. There was unwritten statement being made on caution by the same Saraki, which was tendered. So what happened? The same CCT earlier said that, earlier held in his ruling that there was no need for Saraki to be invited. Now, in the June 14 judgment, they came back to say he was not invited. The same CCT ruling, 24th March ruling, told us that, oh, there was no need for any, nothing was wrong with EFCC, DSS investigating Saraki. The same CCT is telling us that the latest judgment that it was wrong to have involved other government agency to interrogate or investigate Saraki.
All right, and it really became suspicious, especially when the trial started with the bravado of the CCT initially. Anyway, now
that's
really, the question, really. That's what people are saying. Now, of course, Nigerians are talking as well, especially now that the government has appealed, that there is need for the government to even change the prosecution team entirely. A group even suggested Professor Ishe Sage should be the one, that someone that is passionate about fighting anti-corruption should be the one on the side of the government in court to prosecute cases like this.
Don't forget that Professor Sage assignment was different from this. So if they want him to come to prosecute cases, then probably he should be briefed about that. But it's just to head a panel. So it is a different work entirely. That is one. Two, changing of prosecution team. Seriously, Well, we know that in Nigeria, and so far, what we've had in the this fight against corruption, we know that our prosecution team has really failed us in so many ways. You go to court with nothing. No investigation whatsoever. You don't even have concrete evidence to even nail the accused or whoever, the suspect. Then you go to court and all became watered, and you come back and nothing has happened.
Cry foul.
No, nothing has happened. So I think changing of prosecution is another thing. Whether they want to change the prosecution, well, if they really want to do that, they should check themselves. I don't have problems with that, but what I'm saying, if prosecution has to do its job, then they have to be on their toes to do their job. And besides this particular case, I am telling you, you see, when it comes to technicality, you can't rule out what a lawyer can do.
That is even my next question. I was about to say that it seems technicalities now is the problem Nigerians are having, not even the judiciary, because they are the ones using it to kind of throw spanner in any kind of case they want.
When we talk about technicalities, what gives rooms for it? That means there must be a loophole, right? Even the Constitution is not perfect, mind you. So there must be a loophole, and the lawyer only comes to work to capitalize on the loopholes he sees in your charges or your own case. Then he comes to bring it up to say, well, we don't have this in our law. Then what do we have? Let me tell you this. This same CCT, in their ruling, said that, everything is fine. Saraki has no case. Okay, I remember, let me even put it this way. The only power CCT has, if it has to uphold any of no case submission at all, it will be just to discharge. What is CCT's business with discharging and acquitting at the same time? When no defense has been entered, nothing has been done. Somebody filed a no-case submission and you came up to say you are hereby discharged and acquitted. It doesn't have that power to acquit.
It's not even your jurisdiction in the first place.
Not at all. Discharged. Then if there's any case, let them come back later. But doing that, it shows that there's some power play somewhere. So
will you support the move? Of course, now it seems that EFCC has started again to reopen the case against the CCT chairman. That there is more to it than meets the eye, you suspect? Well,
when we get to that bridge, we'll cross it. We'll see it. But seriously, we really need to be sincere with this fight. And I don't know what happened to CCT's panel, because there are two people, and it is sad when I see people of such caliber coming to give such judgment. This particular judgment overrule Court of Appeals decisions, overrule Supreme Court decisions. It is sad. This is a lower court. You can't give judgment that will overrule a subsisting judgment that it has become law. So what happened to you? It is clear in our Evidence Act, that's section 302, 303 of the Evidence Act 2011. It was clear what a public document is. Now, CCT is asking, or is telling us that the documents submitted were not original. You don't need, the section is clear, you don't need to present an original. The CTC of a public document is enough, except there is a contrary evidence.
So it's admissible all the way as an evidence.
Except there is a contrary evidence to show that it is not. It's a public document. CTC is okay for that.
All right. Thank you very much for your analysis.
Thank you.
Legal practitioner Olayinka Ola Daniels, thank you for coming into the studio.
Thank you.